Is your mic on? Please switch on your mic. Thank you.
I'm well, thank you. How are you?
That's better. All right. May we start?
Yes.
Okay. You hold 3 degrees at BA, with English and history as your majors, then did LLB, LLM, both passed cum laude. The BA and LLB you did at UCT?
Correct.
The LLM locally at Wits?
Yes.
Okay. You have a long checkered work history, but I'll focus on the more relevant aspects for today. Your legal career starts in 2000 when you clerked at the Constitutional Court.
That's correct.
That seems to have been quite a busy period for you because I see that you were simultaneously working as an editorial assistant for JUTA.
That was a part-time job.
Of course,
Yeah.
it would have had to be. And you were also working for yourself as a pub quiz master. What is that?
Yes, I have an interest in general knowledge and trivia.
Oh.
And it was one of those kind of things where they ask you obscure facts from the past or the present.
All right. So when you left the Constitutional Court, you went to do your articles at Bowman's.
Correct.
And you worked there for a brief spell. Decided to go to the bar, did your pupillage. That was in 2005. But then you did not join the bar, you went to the LRC.
The Legal Resources Center at the time, and it still does, actually allow advocates who are members of the bar to be employees of the LRC. And it's had that program, I think, ever since it started, when the previous Chief Justice Chaskelson was in that position. And so I was certainly a member of the bar. But the one point that I was very clear on was that I would do that full time. There are a number of people who have come from the bar and worked part-time at the Legal Resources Center who are advocates. But for me, it was important that I should do it full time.
All right. So you were at the Legal Resources Center until 2008?
Yes.
And then decided to go and practice in your own account?
That's
in
right.
September 2008. And that's what you are still doing to date?
Yes.
Okay. Let's see. You have acted as a judge, both in the Labour Court and in the 2 seats of the Gauteng Division of the High Court since 2016.
Yes, the first stint was a pro bono stint through SASLaw, of which I was a member at the time, and that offered an opportunity to do a 1-week stint in the Labour Court.
And you've acted intermittently since for shortish stints, the longest being 10 weeks in Johannesburg in 2023.
Yes, I was lucky enough to do a full term in the first
term. That
term.
was a full term?
Yes, Chief Justice.
All right. So you've acted for a total period of 28 weeks?
Yes, I will also be doing 3 weeks this coming term.
The 4th term?
In the 4th term.
Where? In Johannesburg?
In Johannesburg, yes.
All right. And you've sat in both the civil and criminal courts?
I haven't sat in the criminal trial courts. I've sat in criminal appeals.
All right.
But on the other courts, I believe that I've sat in all of the courts. There may be, I think the one particular court that I haven't sat in is the new insolvency court.
Have you been involved in a criminal trial, even as counsel?
Yes, I have. Particularly early on in my career, there were a number of criminal matters that I was involved in. and that, yeah, I have some experience there.
All right. And you have written a total of 33 judgments, 6 of which have been reported during this acting stints.
Chief Justice,
Is that
the AJP asked for information recently, and I had a chance to look at that. In fact, there are 55 written judgments. It's just that a
55.
number of them weren't on SAFLI, and yes, there are 6 reported judgments amongst
so
the
still
55.
6 reported. Okay. You have also served as a small claims court commissioner since 2011.
Yes, that is, it's been one of the very most fulfilling parts
Yeah.
of my career.
You listed a few reserved judgments in your application form with a promise that they'd be delivered within 3 months from the dates on which they were reserved. Have they been delivered?
No, there are 3 which haven't been delivered, but they are within the 6-month period. I am obviously very concerned to ensure that they will be delivered for that period, and I regret that they weren't delivered within the 3-month period.
All right. You've done a lot of things, but I'm not going to go there. It's late in the afternoon. Hopefully, the other commissioners will touch upon these other achievements of yours. AJP?
Thank you, Chief Justice. Good afternoon.
Good
Advocate
afternoon,
Moultrie.
AJP.
I'm looking at the spreadsheet here. You have not sat in a full court of appeal.
Not in a 3-judge appeal, no.
Yeah. And also, you've never had what we call special civil trials, civil trials for long duration.
That is correct.
Now, you are aware of the complaint that has been made by Mr. Beamish. I just want to understand how you were operating or how the bar is operating. I come from a background of being an attorney, so some of the things that are happening at the bar. Now, when you send these complaints to the JSC, there was an agreement that those complaints should be served on the applicants, right?
The reviews that are prepared.
Yes.
Yes.
And now, after the interviews, and you also published this thing on the, what do you call it?
I understand that the General Counsel of the Bar published them on the website.
Yeah, on their website.
At the time, the General Counsel of the Bar was using the Johannesburg Society of Advocates website to publish them. But it was the Johannesburg Society wasn't publishing them, if I can say.
Now, these reviews, are they still there? Are they still published?
I believe they are still published on the GCB's website, yes.
My concern is some of the reviews that were made are reviews that were made against people who are now appointed as judges. And I need to disclose to this commission that especially those whose reviews have been published, they feel that that was not the correct way to do. Some of them could not be appointed earlier because of those publications. Now, looking at the publications, are you still of the view that they should remain on the website even if a person has been appointed as a judge? Because one of the complaints is that the sexual harassment was there. And when somebody opens that website, that is going to show.
AJP, I should say personally that I have never been supportive of the publication of those reviews. It's well known at the bar that I have always raised this as a concern. It seems to me that the purpose of the reviews is to, as far as can be done, assist this commission in its work. I personally don't believe that it's the correct thing to do, especially in the circumstances that you are referring to. But it's not my decision.
But in your time as a chairperson, did you raise this with the GCB?
Yes.
Was it oral or was it a formal issue that you raised with them?
Orally.
Yeah. The other concern that I want to raise is that some of those judges indicated that because of those publications, they would feel very uncomfortable to sit with you in a full court or a full bench. I know that I'm alive to the fact that it is the decision of this commission to appoint, not the decision of the judges, whether you are appointed or not. But that having been conveyed, how are you going to handle such a situation when you are to sit with one of those judges, if they raise it?
AJP, I would fully respect the views of a judge who is in that position, raising it as being a concern. In fact, as I've indicated to you, I think I would agree with them. I hope that they would understand that the publication of the reviews is not a matter that was my decision. It's not a matter over which I had control, and I say in retrospect, and it's well known at the bar, if I might perhaps use a Trumpianism, that I have been concerned about this from the moment that I took on that job in 2021. This is a conversation that needs to happen, and it must be taken seriously. I'm certain that the General Counsel of the Bar would be amenable to a discussion with the JSC over the question. And if there's anything that I could do to help, I would do it. I haven't been involved in this for some time, but I take it seriously. As far as their views of me are concerned, I would only say that I hold absolutely no personal view about the judges. The process by which those comments are prepared, I've explained, and is not a personal view of mine. It's an attempt, as far as can be done reasonably and with care, to provide information to the JSC. I would understand why they're unhappy about the publication. I would hope they don't hold it personally against me.
So you are saying those publications, they are as they are. There are no further comments that these charges went to the JSC, they were recommended and they've been appointed. So if a junior or a pupil clicks on that website, he or she is just going to see this negative review on the GCB website.
The individual reviews are on the website. What does happen is that if the candidate were to apply again to the JSC, the reviewers who are asked to prepare those reviews are asked to look again at what was said and then to look very carefully at what was found. And so, for example, in relation to at least one of those judges, the next review that was submitted to the GCB indicates that the matter was resolved to the JSC's satisfaction. So, yes, I think it's true that the individual review from a particular year without that information is available on the internet. But the very next review relating to the candidate indicates that the issue was resolved to the satisfaction of the JSC.
Well, I agree with you that this is a matter that needs to be dealt with seriously, because I know of two judges who are not seeing eye to eye, and the leadership of the court, I think they worked together for about 10 years. They never sat together at all. And I don't think it will be in the interest of the judiciary that such events should occur.
AJP, that is very unfortunate, and I would do absolutely everything that I could to make amends as best I could with the judges concerned, and it is not my habit to make enemies or hold grudges. And if appointed, I really hope to work closely and collegially with all the members of the bench.
Yes. Yeah, should you be appointed, I think this is something that the leadership needs to deal with seriously, because you're there to serve and not to make friends.
Absolutely.
So hopefully the leadership of the time will be able to resolve this matter amicably, understanding that it's not personal, but it's just how the organization was operating. Thank you, Chief Justice.
I wish to thank you, AJP, for that.
You seem to suggest that the JSC must expend time and effort persuading the GCP to remove these publications from its website. Why should the JSC have to bear that responsibility?
I apologize for that, giving that impression, CJ. I didn't indicate that. My understanding is that
Well, you said perhaps the JSC and the GCP should have a conversation, and you do everything in your power to ensure that things go, as I understood, you'll correct me if I'm wrong, as I understood it, then you'll try to assist to have these colleagues' complaints addressed to their satisfaction. So how else am I to understand that statement? You want us to go and talk to the GCP and persuade them to?
CJ, no, I will absolutely commit to doing anything that I can. My comment is made specifically in the context of the correspondence that I have attached as Annexure B, pursuant to which the JSC has formally given its agreement to that publication. And to that extent, it seems to me that there has been a formal engagement already some years ago between the JSC and the GCB on this question. But if there is...
Oh, in that context, okay. Thank you. Premier.
Thanks so much, Jay. Good afternoon, Advocate Moultrie.
Good afternoon, Premier.
There is what I see as a damning objection from one investigative journalist, Tony, about your candidature.
We have an objections committee that deals with objections that come in against candidates, and they dealt with that one, and they made the determination that we should not ask this candidate about the merits of that complaint. There was a suggestion that we can perhaps ask him to explain, just articulate it for me, Advocate Ngaito.
Thank you, Chief Justice. It's correct. We've dismissed the objection on its merits insofar as it relates to Advocate Moultrie. What we have said is fair is to ask him to explain the general procedure that is followed by the GCB in making those determinations. Hence, we said nothing when the acting judge president was doing exactly that. Thank you, Chief Justice.
No, Chief Justice, I'll align myself with what you've just said. Thanks.
Sorry, Chief Justice, through you. Chief Justice,
yes,
if I may just make one point. I think I also just to indicate that I've looked at the comments, and you are recommended by almost all the people who wrote to the JSC about your performance and that you can make a contribution to the judiciary.
Thank
I
you.
do not just want to talk about other things. I also want to mention this positive aspect. Thank you, Chief Justice.
Professor?
Thank you, Chief Justice. Good afternoon, Advocate Moultrie.
Professor.
I just want to get a sense from you. We live in a country where competency and excellence is color bound. In other words, when you look at universities, white professors and both female and male are great by virtue of looking at them, even though some of them do not even cut the deal.
Excuse me, you do not?
Do not even rise to the occasion.
Right.
Then the same is true in practice. You look at some of the successful law firms are mainly white owned. Some of the most successful advocates are white, particularly male, and now recently white female. And we see a skewed division of labor, briefing, and instructions across the board. And at the end, it creates a perception that generally white, male, or even female lawyers are excellent in South Africa. And black lawyers, both male and certainly females, are poor. I'm not sure about your experience, and I'm not really asking you about what you have done in the past. I'm now trying to get to where we can actually go as a country. In your view, currently, not what happened in the past, and what happened in the past is crucial, it's important, and we ought not to mince our words on it. But nonetheless, looking forward, based on your experiences, and I'm looking at the number of cases where you appeared as a lead counsel and number of cases where you appeared as a junior, and that is being granted opportunities.
Excuse me,
I'm saying that is being granted opportunities to excel and being able to take opportunities and being as great as you are. What do you think should be done by all of us to level the playing fields, to ensure that we provide opportunities equitably and allow people to fail because of their own mediocrity, not because of the system?
Thank you, Professor. I agree with the premise that very commonly excellence is associated with race, even today. That happens all the time. I should say that it's changing fast, and it can change faster. I was privileged to start my law career at a time when black lawyers of my generation were coming through. I have been lawyers with some of the best lawyers in the country who are black and women. But the reason why they are still exceptions, and unfortunately exceptions, is quite simply ignorance and racism. The answer to the problem is that we've got to address that. There are fundamental structural inequalities in our society that are holding people back. And we end up with a skewed environment wherever there is power. And our obligation as a country is to address that legacy seriously, meaningfully, to the benefit of people who are suffering the effects of that. at a very practical level, there could be many things to do. And from the perspective of legal education, which you're involved in, and from the perspective of professional education, which I'm involved in, we must work hard on those matters to ensure that those structural inequalities are addressed. Is that specific enough? I'm concerned that I may not have an answer, because I suspect that there are not silver bullet answers to this question.
No, I hear you, Advocate Moultrie. Thank you very much for your answer. Thank you, CJ.
Commissioner Muimang?
Thank you, CJ. Good afternoon, Mr. Moultrie.
Good afternoon, Commissioner.
Just one question on my side. One of the criteria that the JSC was inducted on is the independence of the judiciary, and I think you will agree with me that judicial independence is a secret weapon.
Excuse me, I missed that.
I'm saying that you'll agree with me that judicial independence is a secret weapon to promote good governance. Absolutely. Now, I would appreciate if you can allay my fears that your candidature will not be compromised on this fundamental issue of the independence of your independence as a judge, given the discussion that has taken place earlier on. Thank you.
Commissioner, as I understand it, you're referring to the discussion about the General Counsel of the Bar's comments on candidates.
Yes. Look, the thematic areas around judicial independence, amongst them will include the need to stay away and refrain away from membership of any society. It could be secret or it could be otherwise. I suspect you'll understand that we come from the background of the influence of the Broederbond type of influence in all aspects of life. So when there is a reason to suggest that this could find expression in how we take decisions, it becomes a concern. Hence, I'm proposing that you allay my fears in relation to the fact that on this independence, which is critical criteria in terms of evaluating our candidate, there is no cause for concern.
Commissioner, I believe I can allay your fears in the sense that I absolutely reject the thought that a judge could be beholden to any interest other than the Constitution and the law. That is a deep, abiding commitment that I have, and as a practitioner, I have sought, obviously, to fight the cases of my clients within those constraints. As a judge, my obligation is to the law and the Constitution and justice and access to justice. And if there was something that I could refer you to specifically that could prove that, I would, but other than to say, I believe that my entire life has been committed to that principle. My entire professional life.
Thank you. Thank you, CJ.
Commissioner Pillay?
Thank you, Chief Justice. Good afternoon, Advocate Moultrie. You were very gracious in your responses to AJP Ledwaba around judges in the Gauteng division who may take issue with some of the reviews, and you graciously took responsibility for that. I think we have to be very careful here, though, because if you look at the body of work of the JSC over many years, you will see that there's been heavy reliance placed on the GCB's reviews. Perhaps could I ask you, Advocate Moultrie, just to explain, and I know you've done it in Annexure A, but just for the benefit of the public, what process is followed in compiling those reviews?
Thank you, Commissioner. The General Council of the Bar is a federal organization, if I can call it broadly that, of which the provincial bars and other bars are members. The Johannesburg Society of Advocates is one of those bars. It is the General Council of the Bar that produces these reviews, which, as you say, it appears that the JSC has considered useful, and in fact, the correspondence that I refer to indicates that. The GCB, because it doesn't have direct members, asks the constituent bars to please do the work of preparing the reviews. In this year, I was asked to be the chair. We have a standing committee to do that because the work at the Johannesburg Bar, I think, as you know, that is done in this regard is very extensive. Often we had, at the time I was there, I think in that year, over 35 reviews were produced. The then chairperson of the bar...
Just before you continue, perhaps you can give us a sense of how those reviews are compiled and the kind of work that goes into compiling the reviews.
The reviewers are required, first of all, to gather as much information that is publicly available about the candidates, but primarily through their judgments. That is a key part of it. In the old days, that used to be a bit difficult before we had SAFLI, but these days it's made it a little easier. The review teams are to operate in teams. They are not self-selected. They are, in fact, when I was in charge, I was quite careful to ensure that they weren't self-selected. I should say this in relation to the very first year that I took charge of this. I was aware that a number of candidates had previously applied. And because I knew that there had been teams that had produced those reviews before, and due to the time pressure that we were under, I asked the same teams to work again on their reviews. And one of the very important features, and perhaps in thinking about allaying Commissioner Moimang's concerns, I did notice that the review that was produced in the year that I took over said the same things as the reviews from previous years, at least in relation to one of the candidates. And on that basis, I'd like to say conclusively that I was not involved in a campaign against the people. But I apologize for that slight digression. Once the reviews are produced in draft form, my process was to sit as a committee, very carefully ensure that the review teams were able to justify the content of their reviews on the basis of the information that had been gathered. Because in addition to gathering judgments and the like, the review teams are asked, and in fact the entire membership is asked, of their experience of the candidates. In relation to matters that may not have come before this commission in a disciplinary inquiry, things like judicial temperament, matters of particularly cases where advocates who've appeared before judges might feel that they run the risk of victimization should they make a formal complaint. I felt very, very concerned that there was a risk that might produce a situation where a campaign could be undertaken against the candidates. And so, for example, the moment we heard in that year that there was a shortlist, I wrote to the people who had volunteered to be reviewers. They were entirely volunteers. They didn't know which reviews they would be writing. They didn't, and I wrote to them immediately and I said, you will be asked to be part of a team. The reviews must not be written by one person. They must at least have 2 people, if not 3. And you must be prepared to justify to the rest of the committee on the basis of evidence what you've written. We in that particular year, we had difficulties. It was an immediately post-COVID year. And I should say that I had to have that meeting virtually in the sense of emails only. But the process was followed. We then submitted the comments to the GCB. In both of the cases that we're referring to, I informed the chairperson of the GCB that the comments were sensitive and in one case very serious. The GCB then took the decision to submit the comments to the JSC. I should add that in relation to one of the comments, I particularly insisted that the review should indicate that it was the view of the GCB on whose behalf we were writing, that the JSC should put the allegation to the candidate in advance of the interview.
And you, as chairperson of the standing committee, what was your role in relation to those reviews?
First of all, making sure that they were written, making sure they were written on time, interrogating whether they met acceptable standards of, if I can put it, of evidence, although of course we're not talking about particular standards of proof or anything like that, and making sure that they were justifiable for their purpose. I was personally responsible for then sending them to the chairperson of the GCB's committee, who was responsible for submitting them, and then that person did that.
And to what extent do those reviews then reflect your personal views?
Commissioner, no, not at all. My particular view on this was that as the chairperson of the committee, it was critically important that nothing of substance should be changed in the review. My role was to be protective of candidates, which is a matter that I was concerned with and continue to be concerned with. But absolutely not at all. Not a single instance in which I changed the substance of any review. I sometimes made sure that the review was properly framed so that its seriousness could be conveyed.
Thank you. Thank you, Advocate Moultrie.
Thank you, Commissioner.
Thank you, CJ. Good afternoon, Advocate. Earlier you alluded to the fact that you have some judgments that are outstanding, and you apologized for them not having been delivered within 6 months.
Yes.
My understanding is that they are meant to be delivered timeously, which is 3 months. And I just want to understand the reason for these delays. Given, especially in the Gauteng division, we had a sitting judge who applied to another court last week, who explained that she could easily rack up to 20 judgments in 3 weeks. So I think it is important to understand candidates' ability to speedily deal with their outstanding judgment.
Thank you, Commissioner. I completely and absolutely agree that it is a commitment and responsibility of judges to deliver their judgments speedily. In 28 weeks as an acting judge, I've written 55 written judgments, 6 of which have been reported. Also given 42 extempore judgments on substance. I'm not talking about rulings or decisions that a matter is not urgent or something like that. I have given 42 extempore judgments in addition to the 55. During the period since I sat on the 3 cases that are now beyond 3 months, I have sat in 2 additional weeks of urgent court, and I have sat in, I think, 1 additional week of opposed motions. These particular cases, of the 3 that we're referring to, I consider that 2 of them are complex, and in fact, I'm concerned that the law is at the moment unclear in relation to critical elements that have to be decided in those matters. I feel the need to do the research on those aspects, and I wish to give the judgments as soon as possible. I should add that it's particularly difficult and without any way undermining the importance of the principle of speedy justice, it's difficult for practitioners who act on a sort of an ad hoc basis rather than on a sort of a term-by-term basis. And this is commonly the case with advocates because we don't have anyone to run our practices while we're away. And it is difficult, and I regret it, and I apologize.
Thank you. Thank you, CJ.
Thank you very much, CJ. Good afternoon, Advocate Moultrie. I'm pronouncing it correctly.
Minister, yes.
Thank you. I think the first area I want to talk about is one of those areas that I think is quite important as part of access to justice. The work that is done at the small claims court. As a commissioner, having been done that work, I know the DM has been reporting and asking us to improve that work environment. Is work in progress. But sitting here, what are the issues that you think we should be able to pay attention to? But mostly as well in terms of your understanding. Do you think that majority of South Africans are utilizing those courts and they have knowledge of what they can be able to help them with?
Thank you, Minister. I've sat in the Hillbrow Small Claims Court since, I think, 2011. Our court, I say our court, is well staffed by very committed lawyers, advocates, and attorneys. What that means, in fact, is that I only get to sit in that as a small claims commissioner about once every 2 months. And I miss it when I'm not there. And the reason why I miss it is because it's exactly that. That is a place where justice happens in a real way. I regularly deal with 6 opposed trials between 5 o'clock and 9 o'clock at night. We might think that that is an obvious sign that it must be unfair, but it's not, because what happens there is that those litigants fully understand that what's going on is an attempt by the commissioner to understand their problem, to bring the parties together in a very unique way. It's not formal mediation. It's not formal arbitration. It's in a very direct way. I have I've never been reviewed, and I find the parties leave the court, both of them, shaking hands and agreeing, even though one has lost. So I'm an enormous fan of the small claims court. I'm a little concerned about this, though. I participated in the Deputy Minister's consultation with the profession on the expansion of its jurisdiction recently, and some very thoughtful points were made. If the jurisdiction of the Small Claims Court is to be expanded, they have to be properly resourced. I'm not here talking about necessarily the salaries of the presiding officers, but we need to ensure that that efficient service that, at least in my court, we're able to give can be broadly rolled out. So also understanding that what really happens there, and the reason why it seems to me that it can work, is because of the possibility of something like inquisitorial justice as opposed to adversarial justice. But what that raises, of course, are deep concerns about the quality of the people who do it. Because once you get an inquisitorial commissioner who is not doing a good job and doesn't have the skills, you actually open the door potentially to serious injustice. But I strongly support them. I support the expansion of their jurisdiction, and I do believe it's part of the solution to access to justice, which is of critical concern.
Thank you. Just linking that work that you're doing at the Small Claims Court, but also looking at the LRC work, because I do note that there's quite a lot of work that you've done in terms of legal resource to assert and develop their rights in terms of communities, and quite a number of, I think, work that contributes towards access to justice. Again, looking at that work in terms of small claim court, but broadly, where you've been involved in particular within Gauteng communities, how do you see us expanding on the access to justice broadly, beyond just the small claims? The small claims, they come in, they go, but you've acted in the High Court as well. And I'm taking advantage of this vast experience that we have in various areas and working with communities in terms of this area of work that we could be able to expand, especially I'm looking in my area as a Minister of Justice.
Minister, thank you for the reference to my experience. I feel like I learn all the time, so I don't feel experienced. I should say this. I think that there are 4 elements to this problem of access to justice, at least. I think we need to think about legal education. I'm not talking about just lawyers. I'm talking about the legal education of our people to understand that the law has been given a central role in assisting with the vision of the Constitution. Secondly, we've got to think about infrastructure, where those courts are, where they should be placed, what their jurisdiction should be, whether they're magistrates' courts or small claims courts or superior courts and circuit courts. Very practical physical problems. We have to work on legal costs. Legal costs are exorbitant. I would suggest that one of the reasons why legal costs are exorbitant is because we have this difficulty with legal education. One of the reasons why I do advocacy training, for example, is I believe that well-trained advocates produce and present cases efficiently before courts at low cost with good results. Poorly trained advocates or untrained advocates and representatives delay cases and increase costs. So we've got to work on that. And then we have to work on the overburdened system that we have. The interventions that have been made, for example, in our division by the leadership of our courts are extraordinary. Such care has been taken to ensure that the judges are not overburdened, that they get to sit in the opposed courts only a few times and the urgent courts only in a few times, so that they can write their judgments. We have the mediation protocol. We will see how that works. We have case management, difficult to work out. We need also to think about legislation. Does every case need to be decided by a High Court judge? Does every one of those unopposed motions need to be decided by a High Court judge? As lawyers in courts, there's nothing we can do about that. But we need to think about that. And then the last important thing is that the judges, the colleagues in this room who write their judgments, must help to make the law clear. Because if the law is not clear, people will just take a chance. And that excludes justice. We've got to have the right cases before the courts. And those are just four things that I think are part of the problem. I wouldn't think that I could have the solution.
Thank you very much. Thank you.
Commissioner Steinberg?
Thank you, Chief Justice. Just returning to Mr. Beamish's complaint. When I read the complaint, I contacted the chair of the GCB to get a wider mandate in order to respond. And the message I was asked to communicate was that any criticism about the process should not be laid at Advocate Moultrie's door. He was actually doing a service at the time for the GCB and implementing a process that he didn't make, but that the GCB had evolved over the years and may well need further evolving, that it would be unfair to blame him for any of it. In fact, he gave selflessly many, many hours and days in coordinating this. And yeah, I must add to what Commissioner Pillay said, that many of my colleagues here have said how much they rely on GCB's reviews. It's the only body that actually looks at the judgments and then gives a guide to us as to which judgments to look at, etc. So I think we must just be careful not to throw the baby out with the bathwater. Finally, Chief Justice, just to alert you, in Advocate Moultrie's response to the complaint, he included two letters. The one is dated 4th of March 2013. It's from William Makari SC, who's then the chairperson of Joburg Bar Council, and asks the Chief Justice in his capacity as chairman of the JSC for permission to publish the comment. And the response comes on the 27th of 5th, 2013, from Mr. Chulani to say, yes, you should. I think that was the last it was left at. Thanks.
Thank you, Commissioner Steinberg. Are those follow-ups? Okay. Yours is a follow-up?
Yes.
Okay, go ahead.
Thank you very much, CJ. I think we need to be very careful. When we can accept that GCB is doing a wonderful job, but to say that it is the only body that carefully looks at the judgments, I think it's wrong. It is important to note that all the bodies are playing a meaningful role in this particular process. And we should not come out as the JSC as if we are overpraising one body and we are actually undermining the work that is done by the other bodies. And we have not yet done a SWOT analysis as to who does what when on an objective basis. It's okay to say the issue that we are dealing with, we can address it and say members of the body do rely from time to time from the work that is done by the GCB, and we can leave it there. I think we have to be very careful because otherwise we are going to end up with a situation whereby we discourage other bodies from participating in our process, and we are going to be a little bit poorer should we get to that particular extent. I just want to caution us to be very careful in how we frame things. Thank you very much, CJ.
Thank you for that intervention, Prof. And of course, I agree with you. And I just want to remind us that our record is replete with references to all the comments that are made by the other law board. Issues are raised with candidates coming from all these law bodies all the time. That has been happening in these 2 weeks. So I don't think anyone who follows these proceedings would be fair in an assessment that says the GCB is given preference. We look at AFT, we look at LSA. Someone was referring, I think it was Commissioner Ngugaitobi, to LAA that I have not even heard of before, just this morning. So all the law bodies, their inputs are valued and we do read them, and issues they raised are raised with the candidates. Commissioner Mangena?
May I just say that?
Oh, you had not finished?
No, I just want to say that I apologize if that's how it came across, because I certainly didn't mean that. Of course, we rely on everyone's, all the bodies' comments. Thank you.
Thank you, Commissioner. Commissioner Mangena?
Apology accepted. Advocate Moultrie, good afternoon.
Good afternoon, Commissioner.
Yes, I want to canvass you a completely different aspect, and believe you me, it is important because it deals with knowledge production, legal knowledge production in our country, and which is a contested thing. I note that you are CV. You say you were an editorial assistant to Judah and Company. And is that the Judah and Company that produces law reports?
Yes, I had a very particular job on what was called the Annual Survey of South African Law. It's now called, I think, the Yearbook of South African Law. Professor Moramachai, I think, writes a number of the topics there. My job was to research every academic article that had been written in the country in the year, and to identify new legislation for every chapter, and then write what we called the literature lists that would appear at the end of those paragraphs. And I should say I didn't do the work for any money.
Yes, thank you so much. There is an observation, it may be my observation, that black academics are struggling to have their articles published, and there is a sense in which it is suspected that there is gatekeeping. An impression is created that black academics are lazy, they are not writing, and when the contrary may be that they are being blocked. Any comment?
Unfortunately, I can't. I haven't been in academia for a very long time. I don't have a good sense of that. I do try and keep up with academic writing in the published articles, but if what you're saying is correct, then I obviously would have a skewed view.
Related to that, you may have noticed, more especially as a person who was part of the committee at the GCB, that comments when people apply for judicial positions. Great reliance is also placed on judgments published by law reports. Do you perhaps know why is it that it is difficult for judges to have their judgments reported on when they've marked them reportable? What is the selection criteria used to determine which judgments get to be reported and others not reported?
Yes, Commissioner, both, well, at least I'm aware of two very high-profile legal publishers, and they have both published the criteria by which they choose the judgments. They have, each law report set has, as I understand it, an editorial committee, and that their obligation is to apply those criteria to the choices of judgments that are published.
There are.
I've exhausted your quota of questions, Commissioner Mangen.
Thank you, Chief Justice. It was a kind reminder. I accept. Thank you so much.
Thank you, Chief Justice, Mr. Moultrie, SC. I'm here. I must apologize that we are taking you from this corner to the other with our questions. Mine really relate to the second issue that was raised by the Minister. And in your response, you mentioned about 4, but ultimately I think it became 5 issues. But I did not hear you mentioning the issue of language in the courts, whether is it relevant or not. Obviously, for now, the vexed issue is why should it only be English when we've got so many other official languages. Some proponents of the use of other languages seemed to be interested in protecting the Afrikaans language. We know it is already developed, and relying only on English, it means now it's not going to be used. But they are well aware, these are the views that which are being expressed, that they know that other languages will take time to be developed to the extent that they can be utilized. Now, maybe you could assist, what views can you share with us that interventions that can be put in place to promote all these other languages? Perhaps even include the journals, publications which also encompass articles and views on these other languages. Thank you.
Thank you, JP. I should say that in the first place, there is no legal concept that cannot be expressed in any language. It may require care to do it, and it may require study. In my case, it would require years and years of study. But there is no reason why it can't be done. The question is should we do it? And if so, is there a cost involved? But if there is a will, and if there is a cost involved, I wouldn't necessarily know, then there is no reason why it shouldn't be done. Does it answer the question? I remember when the SCA produced its first judgment that was not in English or Afrikaans. It was a moment of change. It was good.
Conscious decision by the government to spend more resources in developing these other languages, will that not assist?
It may be so. I don't feel like I'm an expert in language development. I don't understand. I don't think I could say what it might involve.
Thank you.
Commissioner Hassan?
Thank you very much, Chief Justice. Advocate, I think you have answered this to some extent, but I just want to pose it in case there's 1 or 2 elements you might have forgotten or you didn't necessarily put in. But I was going to ask you about structural transformation. And what does that look like, not just in who sits on the bench, but who has access to it, who can afford to litigate, who gets the clerkships, who gets briefed, and of course, whose lived realities are reflected in our jurisprudence.
And whose, excuse me?
And whose lived realities of the poor and the working class in particular are reflected in our jurisprudence.
If one is to do justice through human beings, one will be dealing with prejudice. We're all prejudiced. Cannot help this. It is part of who we are. The question is, how do we raise those to the surface? I was looking at the Judicial Code of Conduct. In note 7.2, it says, we are to strive to be aware of and understand the many differences between persons and to remain informed about changing social attitudes and values. It also says the multicultural nature of South African society calls for special sensitivity for the perception and sensibilities of all affected by court proceedings. This is an obligation that we have, or that the judiciary has. And it's also an obligation that lawyers have. Commissioner, once again, I need to be careful that I've answered your question.
No, I think you have also in previous ones. And then just the last point is, how do we move transformation from a narrative, where I think we're sometimes a little bit guilty of just talking about it, but how do we actually institutionalize that transformation in this space?
Institutions have the ability to produce lasting, written plans and policies, unlike human beings. Human beings will and must act in their own capacity at all times. But what institutions do is that they can write it down. They can make it applicable. So, for example, if you look at I was looking at the sexual harassment policy that was recently published. We were asked to sign our commitment to that as acting judges. It is critical that that policy must be monitored. It is critical that we must see and gather information so that we can see whether it is having a structural change or not. Otherwise, the risk is that it's just going to be lip service. I think that institutions are the answer. I think leadership is the answer.
Commissioner Ngweto?
Commissioner Pillay had the question on sexual harassment and wanted to follow up.
He's being so gracious. May I follow up, CJ, on the sexual harassment? Advocate Moultrie, I just have two follow-up questions in response to your answer to Commissioner Hassan. The first one is, you've said you've read the sexual harassment policy, and you will see that the sexual harassment policy does extend quite widely to conduct of a judicial officer, both, it seems, arguably, to conduct during your official role and capacity, but also to extrajudicial conduct. Do you think that's appropriate, and what kind of difficulties do you envisage in implementing that?
It seems that the biggest difficulty is to understand the interplay between the field of operation of the policy and the formal requirements of judicial conduct as articulated through concepts such as ultimately impeachment, but through the Judicial Code. And finding how to balance those processes. For example, if one, I looked at the ADR processes and the concept of an anonymous complaint. As I understand it, if an anonymous complaint is made, it's made and it's recorded, and that's part of the monitoring. It can only go further, of course, if it is not an anonymous complaint. And what I think that the policy does well is recognize where some of those lines lie. And those, I do consider that those will be some of the difficulties. And what you are referring to, in fact, around a judge's personal life and a judge's public life are going to be questions that arise in that context.
And since you considered the ADR process, the complaints process, do you see any difficulties with sexual harassment complaints being put through those processes?
Yeah, I could imagine that there will be people who have difficulties and who will challenge them, and our difficulty will be, as a society, how we deal with that. But that will be the difficulty. I can't say that in principle. I can tell you, I can give you a legal opinion on the question right
And then
now.
just to come back to the transformation question, you know that briefing patterns plays a big role in the transformation debate. Can you just tell us what steps you've taken to address briefing patterns and the empowerment of Black and women juniors in your practice?
I'm committed to it. At every opportunity I take that I'm given to help recommend a junior, I ensure that I recommend blacks and women. It is not always the case that I exclusively recommend blacks and women. And I have been grateful to have, I have persuaded a number of attorneys to take on young advocates who they haven't previously, and to wonderful effect. I do that. I should say that I find resistance amongst attorneys. On two occasions, on one occasion, I was thrown off a pro bono brief for asking them to brief a junior and to pay them.
Can I ask, why does that resistance happen? Can you venture a guess of why do attorneys resist briefing black advocates?
It's just prejudice. It's the fear of the unknown.
And how do we deal with that resistance?
Well, we argue back. Say, no, I disagree. Here is somebody who's perfect for this case. As you know, the Johannesburg Bar is at the moment filled with brilliant young juniors, men and women, who don't have opportunities. We are teaching them. We are training them. We are making them better lawyers. The attorneys are not trusting us.
Thank you, Chief Justice.
Advocate Moultrie, good evening.
Good evening, Commissioner.
I think that you've been incredibly modest in the sort of way you have sold yourself on a number of respects. And I want to just challenge you to be more expressive in relation to the work you've done on community empowerment, legal work, in relation to the work you've done at the bar to enhance transformation, in relation to the work you've done on training as you are currently my chairperson in the Human Rights Committee, which is one of the subcommittees of the Johannesburg Society of Advocates. I was just looking at the letter nominating you from Advocate Benny Makula, who mentions your role at the Commission of Inquiry into the leadership or the kingship of the Bakhatla Bakhafel, which went on for years. most of those are not known to a number of us. And we depend on you to educate us about the incredible role you've played up to this point. You know, I was interested, I was glad Commissioner Pillay came before me because I was going to probe you on transformation. Because transformation is one of those things that many of us claim commitment, but very few actually do something about it. In my own experience with you is that you've been one of the few that actually do something about it and go beyond exaltative statements. People coming, trying to get jobs as judges and claiming commitment to the bar, to the transformation of the bar, others wanting senior counsel status, claiming commitment. But you've been ahead of the curve. So can you just set out in brief, not in detail, not what you will do, but what you've done, which is probably the best measure of what you will do.
Thank you, Commissioner. As a lawyer, I believe in evidence and not empty rhetoric. So for me, to answer your question, I would want to do a couple of things. One is it transformative? Is it transformative to represent a community? If that is an area of law that you are interested in. I'm not wanting to argue against you. What I would like to say though is tell no lies, claim no easy victories. Nobody can understand the level of transformation from an individual case for an individual person. But I'll tell you this, the silicosis case. Fundamentally, I was one of the very first people involved in that case. A resources center because I felt that it was something that needed to be done. You will recall that we worked first on a test case. We did all the work on that. We had 1 million pages of discovery from the mining companies, which we read. We developed the expert opinions that formed the foundation of the later class action. Our case was settled, but we laid the basis. After that, I moved to the BioWatch case. One day, BioWatch representative came into my office and said, "We've lost this case. Our advocate says we can't appeal on costs only." We sat down, we thought about it, we strategized it, we developed it, we fought it, we lost it in the full bench. I refused leave to appeal at the SCA. We went to the Constitutional Court, where I was very grateful to be led by Gilbert Marcus. The Olivia Road case was an opportunity there. I need to pick up something about what Commissioner Mangena said. These are opportunities that may have been given to me because of the privilege that I have. So to claim them it's not about me. Whole teams of people did these things. Mazibuko, the first time I ever got to lead a junior in the Constitutional Court, was an opportunity to work on socio-economic rights. We worked on the evictions of the miners who became the miners who were living in those tents at Marikana, who were evicted out of the Kroondal and Marikana hostels. All of this work we did because they were our clients. Of course, it's transformative. You choose to do it. But I can't claim it.
Thank you. I think I'm satisfied with that. Also with your qualifier that you're not claiming these victories. The last question, not an invitation for virtue extolling.
Apologies, Chief Justice.
Is around the, I just don't want to be vague on what the response is. And I don't want you to find out who are the two judges the JP is talking about, the AJP is talking about. But it is a practical scenario where in this country, judges have said we refuse to sit with Judge so-and-so for ethical reasons. In your case, you may feel that it is unfair that people say they don't want to sit with you in a full court or full bench. It's unfair. They should not say that. But they've said it because a lot of things that get said are unfair.
Sorry, I wasn't aware that any judge had said that.
No, that's what the AJP, I thought, was suggesting. Maybe let me clarify if that is correct or not before we go on a dangerous path.
Correct.
Yes, I'm correct, yes. So, and you may feel it's unfair. They should not say that. But it's happened, unfair as it is. The real question about your own sort of judicial response is, what is your judicial response there? Somebody says, Mr. Moultrie, I'm terribly sorry. Judge Moultrie, I'm terribly sorry. I'm not going to sit with you. And they give you a reason, and you believe the reason to be wrong, unfounded, unfair. But it's really testing you about how you will react to that kind of a response.
Well, there are two responses. As a human being, one seeks peace and reconciliation, if you can. As a judge, that if I were to be appointed as a judge, that would be an extremely serious impingement on judicial authority. I can't see how that could happen.
But is there anything practical you think you can do? Are you going to go and say, let me go and see them in chambers and let me explain myself? And if they are hurt by my conduct, let me apologize. In other words, let me humble myself. Thereafter, let me go and see the head of the court and make sure there's reconciliation, because we need harmony in the division.
I will most certainly do that, and that's why I premised it from the first perspective of at a personal level. Absolutely, I have absolutely no animus whatsoever against this. I understand that this particular journalist has got the wrong end of the stick. And we have to work together. We're human beings. And I would want to make peace with them.
Thank you, Chief Justice.
President. Thank you very much, CJ. Good evening, Mr. Moultrie.
Good evening.
How are you?
I'm well, thank you. And how are you?
I'm also fine, thank you. My question is, do you think that diversity on the bench is essential, especially in terms of judges coming from different backgrounds? If not, why not? If so, how do you think it enhances public confidence in the judiciary? Thank you.
I do think it's absolutely critical. I think that a judiciary that reflects, I mean, apart from the fact that the Constitution requires this commission to take it into account, but the Constitution sets the law, it seems to me, as one of the most important ways in which we are going to achieve the vision that it sets. If the Constitution if the judges don't have the confidence to say, someone like me, and not everyone is alike, but someone who I can identify with, maybe at a color level, at a race level, at a gender level, is there, then I can be confident that this is a country that will work for me. And we need everyone to think that, because if we don't empower our people, we can't succeed. So I hope that's the answer. It is critically important, and that's the reason.
Thank you, Mr. Moultrie. Thank you, CJ.
Commissioner Matolo-Dlebo.
Thank you, CJ, and good evening, Advocate Moultrie.
Good evening, Commissioner.
You know, we have been speaking about transformation a lot, and I understand from Advocate Mugai, you are very modest. You are not blowing your own trumpet. You know, one of the things that worries me every time is that we interview people for judges' positions, and everybody will tell us that this is what they do, brief junior and whatever. But one of my duties is to, as a stakeholder engagement of the legal sector coach, we actually go to bar councils and try and find out from the young advocates, female advocates, how do they see, how do the seniors share the work, or do they actually give them briefs, or do there's this thing called deviling or whatever. And the information that you're getting is not what I'm getting here. I'm not saying it's you, but I'm just thinking there's something that needs to be done. And how do you think maybe we can get that information, right information, to say there is transformation going on?
Commissioner, we shouldn't, in my view, start with the intention of showing that there is transformation going on. We should start with the intention of finding out whether there is transformation going on. And I do think that speaking to the junior people is a good idea, because they know and they experience. However, for the very same reasons that advocates who find difficulties with judicial temperament, etc., might not want to talk, junior advocates might not want to talk. So I don't know what the mechanism would be, but I can imagine that there is one. And I know that you're an attorney, and we depend on you for work. I'm not placing the responsibility at your door. We need to do it together.
Maybe I'll have another chance to talk to you offline.
Commissioner Shabagumdawu.
Thank you, CJ. CJ, I'll just follow up on what Commissioner Matolo-Dlebo just said. Advocate, good evening.
Good evening.
It's not yet evening. I'm looking outside and I see the rays of the sun that's still setting.
CJ, 5 o'clock, it's 5:30 now. Advocate, there are attempts that have been made just to deal with the skewed briefing patterns and the transformation. There's a legal sector code which has been gazetted. Of course, it's being challenged. I just want to get your personal view. Do you think it will assist in this challenge that we are having?
I'm worried that it won't. I can't tell you the full reasons for that.
No, you don't have to tell me the full reason, because obviously it's before court now. I just wanted to get your view.
I hope it does.
Thank you.
Okay. Anyone else? All right, your torture is over.
Thank you, Chief
Before you
Justice.
go, I just want to thank you for applying for this position. Of course, I'm not promising that you'll be recommended for appointment, but I must say that it gives hope for the future of our judiciary when our senior lawyers with busy practices show a preparedness to join the bench. And one hopes that more Black and women senior lawyers will do so. Thank you. You're excused.
CJ, advocate.